Good afternoon, everybody. Jeff Jenkins and Eric Klayman here again. That's assuming that I'm talking to anyone. We've got an audience out there somewhere. But anyway, here we are with another one of our Facebook Live presentations that we do generally every Thursday at 2 p.m. And if you've not listened before, Eric and I are both bankruptcy attorneys. We have been for 30 some years. And so a lot of what we talk about is linked to bankruptcy. It's not just about bankruptcy. As we've gone from episode to episode, it's been a lot about what's going on with the coronavirus and all the legislation that's come out of that, what the governor has been doing and what the CDC does and so on and so on. But today, Eric's going to tell you a little story that he really wanted to tell. So I said, okay. He convinced me. Anyway, we're going to be talking about things that if you're having financial problems and you're thinking about filing bankruptcy, these are things that you should not do, because we'll explain why.
Exactly. And you can check our website right there. It's right on the screen. And you can go to the video portion and you can catch up on all of our missed episodes. And what Jeff said's right. It's not just about bankruptcy. A lot of it is just about making good financial decisions, getting good advice, and making good decisions. And one person that has not made good decisions in his life, despite having a lot of money, is the former New York Yankees baseball player, Joe Pepitone. Joe Pepitone played baseball in the 60s with the Yankees. Then he played with the Cubs and a couple of other teams very briefly. And he was kind of famous playing for the Yankees. They won all those World Series. It made you famous. He was their starting first baseman. He was an all-star. He won a Golden Glove, indicating he was the best fielder at his position, and had an accomplished career. Rumor has it that he received a $25,000 signing bonus in 1962. Not a signing bonus, but he made the major league team bonus of $25,000 in 1962. And as he was driving from New York to Florida for spring training, he spent all the money. And they say $25,000, Jeff, in 1962 is over $200,000.
Yeah, it's worth about, what, how much is that? 100 times? What?
Yeah, or at least
10
or 12 times maybe.
Worth, yeah.
So basically, you're giving $200,000 to that, and on a drive from New York to Florida, he spent all his money. When he was
You have to have an awful good time.
When he was 17 and in high school, he was shot, and he didn't press charges. He's been in jail after his baseball career several times for drunk driving, for getting into fights, and he's had a colorful life, and he has spent a lot of money. He spent so much money that 10 or 12 years ago, he had to file bankruptcy. And the pension that these baseball players get is very significant. So he has good income. He still had to file bankruptcy. And we see that, Jeff, all the time. Let's take a step back. We've represented many lawyers, doctors, teachers, people who make really good salaries.
Dentists, accountants. We've represented football players.
Yes.
For the Eagles.
Yes.
Or people who were just playing for the Eagles. Now they weren't playing for anybody. And they were used to making $800,000 or $1 million, and now they're making nothing.
So high income is not a barrier to filing bankruptcy.
No.
And I'm not disparaging Mr. Pepitone's decision to file bankruptcy. I'm sure it was a good decision. Filed bankruptcy, and he obtained what's called a discharge of his debts. A discharge means you don't owe anyone any more money, and that's what we strive for in our bankruptcy cases. He filed a Chapter 7, which is probably the most straightforward type of bankruptcy. And then Chapter 7, Jeff, one thing that you and I really, really stress to our clients is the accuracy of the listing of assets. And Schedule A, you're supposed to list all your real estate and timeshares. And Schedule B is pages and pages asking you to list all your assets that are not real estate. And Joe did that with his bankruptcy counsel 10, 12 years ago and obtained his discharge. Well, this month, in August 2021, he hired new lawyers to sue the Baseball Hall of Fame, claiming that the bat which Mickey Mantle hit home run number 500 with was a Joe Pepitone signature bat, belonged to Joe Pepitone, and had to be returned from the Baseball Hall of Fame to Joe Pepitone, and he should be given $1 million because he hasn't had the access to the bat for this time. Well, if you're going to make a demand, you might as well make a demand, right? You can always negotiate from a position of strength.
Sure.
So I want the bat plus $1 million. And the bat, look, it was Mickey Mantle, 500th home run. The bat, they say, if it was for sale, would be worth more than $1 million itself. And we've seen during COVID that these collections, these collectibles, baseball cards, coin collections, electronic media, art, music, everything, all these collectibles are going up. So I'm sure the bat's worth a lot of money. And Baseball Hall of Fame hired lawyers and have filed a motion to dismiss his case, noting a number of things, which is that he waited to sue the Baseball Hall of Fame until everybody else had died, so there's no other witnesses but him. Meanwhile, the Baseball Hall of Fame has had the bat for 40 years, more than 40 years, nearly 50 years, in fact. Well, about 45 years. So they've had the bat. He waited till everyone to die. But the big thing that the other thing was, it's a Joe Pepitone signature bat, but they contacted Louisville Slugger and they got the original contract that Louisville Slugger and Joe Pepitone signed that said that they could use Joe Pepitone's signature on the bats. But what did they have to do? They had to give Joe Pepitone a bag of golf clubs. So I'm sure the golf clubs were nice,
Yeah.
But so in effect, he's already given away his licensing of his signature on the bat. So regardless, we're bankruptcy attorneys, and the most interesting defense is this. When Joe Pepitone completed Schedule B of his bankruptcy schedules, he did not list the bat as an asset. So he either was lying then and did not disclose an asset worth at least $1 million on his bankruptcy petition, or he's lying now claiming that he now owns the baseball bat worth $1 million. Jeff, how you ruling on this?
Well, I mean, it makes all the sense in the world to me. I mean, when you list what you've got, you have to list everything. And just like in this situation, if you go back years later or something and say, well, I really have a claim against somebody, I'm going to sue somebody for, and it's not something that you mention in your bankruptcy schedules, that's a great defense for the person you're going after, because like you said, he lied one time or another, either lied on his bankruptcy or is lying right now.
We see that a lot on personal injury cases in the published opinions that we read. We don't see it in our office. We really try to stress to our clients the importance of listing every single asset. It goes back and forth at review. But many times people don't tell their lawyer, or whatever happens, that a personal injury case is not listed as an asset on a bankruptcy petition. And the lawyers for these insurance companies defending the personal injury tortfeasor, it's simple to check a bankruptcy petition. Have you ever filed, right? It's pretty simple to check that. Then you look at the schedules. You must list all of your assets, even if they're worthless. Even if you think they're worthless, have somebody else tell you that they're worthless. But you as a client, when you call our firm at the phone number right below, is that cool? Not only will you get Jeff's free book, but you're going to get real good advice like this, which is don't be a Joe Pepitone. List all of your assets on your bankruptcy schedules.
Yeah, there's even a thing in Schedule B for collectibles. It asks you if you have any collectibles that are worth any amount of money, like a baseball card collection or a coin collection or a porcelain doll collection or a baseball bat.
From Mickey Mantle that hit his 500th home run. A story was Joe Pepitone hit a home run that day with that bat, and Mickey Mantle was up subsequently and grabbed the bat, and Joe said to him, "Take mine, there's one more home run left in the bat." And so he took Joe's bat, hit the home run, and Mickey Mantle had a pretty good career and a pretty good restaurant. And I think the restaurant just closed in New York, Mantle's Steakhouse. It's been open for a long time. But Joe Pepitone, a little different life. Jeff, what other advice can we give people about filing bankruptcy?
Well, let's talk about not things just like that, but instances where you get rid of things you have and give them to someone else, and many times a relative, to try to preserve them despite a bankruptcy filing. like transferring your house to a child, your spouse, whatever, and then filing a bankruptcy. What about that, Eric?
Well, I guess theoretically you can do anything, but you just have to disclose it. The problem, of course, is that when you do transfer an asset, it's not really transferred for bankruptcy purposes unless a period of time has gone in between. In other words, if I gave Jeff my gold watch 25 years ago, there's no place on the bankruptcy petition to list that gift.
No, we'd be fine.
It's 25 years ago. It's a gift. However, if that same watch I gave to Jeff 3 days before I filed bankruptcy, and then I don't list the watch as an asset on the bankruptcy petition, then we're not fine because both of us will have issues. You as the recipient and me as someone who signed a bankruptcy petition and didn't disclose the transfer.
Mhm.
If you make a transfer within 2 years of the bankruptcy filing, it definitely has to go in the bankruptcy petition. There's no question about that. There's questions about that. And sometimes the court, the trustee, interested creditors can go back under New Jersey's law, I suppose, 4 years if there's a real estate transfer or a fraudulent transfer, but there's no place to disclose that on the bankruptcy schedules. It's just 2 years.
Yeah, there's a different time period, whether it's for less than the fair market value of the real estate, or is it with an intent to defraud creditors?
Right.
Maybe one might be 5, one might be 7. And the bankruptcy trustee can use those aspects of our state law to take advantage of those time periods.
But going back to the gold watch, if I give you a gold watch 3 days before we file bankruptcy, the trust, hopefully I've revealed in my schedules. If I don't, the trustee finds out about it. If I do and the trustee finds out about it, they're not necessarily going to ask me back for the gold watch. I don't have it anymore, Jeff. So who's going to get involved in the bankruptcy case?
They're going to sue me.
The person. So here you are. You have this asset. You give it to your buddy. You give it to your mother. You give it to your son before you file bankruptcy. You are not just making a mess for you. You're making a mess for you too. And to keep you out of trouble when you sign your bankruptcy petition, make sure it's accurate and go overboard with disclosing things. As long as you disclose it, you can't really get in trouble. You're telling the truth.
Right.
But some transactions don't make a bankruptcy case work as well as they would work if, again, we wait a little bit of time. Remember, if I gave Jeff his gold watch 25 years ago, 10 years ago, I don't have to worry about that kind of gift. It's not to be disclosed, and it's considered given, and it's not a fraud. It's not a preference. It's none of those horrible bankruptcy words that we deal with.
Eric, what about if you have a retirement account and you see that you're going to file a bankruptcy, taking money out of the retirement account and doing something with it? Like, let's say you just put it in your bank account, or you go out and buy a car for cash.
Yeah, that happens. And don't. It's interesting, both the federal law, but more importantly, Jeff, the state law. New Jersey's law is very, very strong on this. Money in a qualified retirement account, IRA, 401k, Roth IRA, 403b, it used to be KEO accounts. All this stuff are called qualified retirement accounts. You can Google the term. If you have money in that account, except under the most extraordinary circumstances, that money is protected from creditors. You can't dump a whole load of money into it right before you're filing bankruptcy. That's again a transfer. We don't want to do that. But if you have the money in a retirement account, don't cash it out in anticipation of a bankruptcy case, because a couple things are going to happen. In most situations, except if it's a Roth IRA, I suppose, you don't have to pay taxes on it. So here you are getting ready to file bankruptcy, and you're going to have a new bill. Yeah. People want a fresh start when they file bankruptcy. So by converting retirement funds to non-retirement funds, it's taxable. And under most situations, consult your tax advisor for
Depending on your age, it'll be a penalty.
Could be a penalty if you're not 559 and a half.
taxes.
Yeah, plus taxes. So why do you want to incur more debt to file bankruptcy? No. And secondly, you're converting an asset that we said both the federal law and the state law protects from creditors, doesn't count. It's yours. And you're converting into an expensive car or money in a bank, which can then sometimes be liquidated, or you'd have to pay people back something over 3 to 5 years in a Chapter 13 case, which you ordinarily would not have to pay had the money just been called retirement funds. Agreed?
Yes, absolutely. As soon as you take that money out of the retirement account and put it in your checking account, or buy something with it, it's no longer retirement money. It may have come from the retirement account, but now you've got a thing where you've got a bigger checking account, and that the trustee can look at and lay his hands on. So,
You have another good one?
what about selling assets to friends? Or let's say, you're giving them a good deal, maybe less than what the thing is really worth. Car, your lawnmower.
We do see that from time to time. Look, by the time we talked earlier, there are many of our clients who are accountants, lawyers, teachers, doctors, dentists, football players, sorry, who make a good living. And they have money, they just need to file bankruptcy for a variety of reasons. So we talk to them and we can help them. There's some people who are desperately poor right now. The economy's hard. So they have to sell their lawnmower. They have to, or they feel they do. They have to sell a car. They have to do something to help them out. There's nothing wrong with that. If you put an ad in Craigslist and sell your lawnmower for $200, God bless you, you get $200 for a lawnmower. You have to disclose it on the bankruptcy petition. You should disclose how you sold it, to whom you sold it, and things like that. But if you take my gold watch, Jeff gave it back to me, and right before I file bankruptcy, I sell it to my neighbor for $300, and that watch is a very expensive watch. Then it has to be disclosed, and it's fraudulent, because you are taking an asset worth a lot of money and converting it to $300, so that you'll have less assets for the benefit of creditors. As we talked earlier, Jeff, you have to disclose such a transaction, certainly. But you're also, the recipient of that is very much going to be treated as a recipient of a gift made outside the normal course right before filing bankruptcy.
Yeah, and so the trustee, whether it's a Chapter 7 or a Chapter 13, well, in a Chapter 13, you could always modify the plan to pay more to creditors to make up for that little faux pas. But a Chapter 7 trustee could sue the person that got the merchandise, that got the lawnmower or the gold watch or whatever. And that's what would happen. And a lot of times in these situations, we see the transfer being among relatives. Your mother helped you out for 2 years, and you're going to give her $10,000 now right before the bankruptcy is filed, and you can't do that because the trustee will sue your mother for the money. So it's just you have to be very careful about things like that. And we do, people don't understand a lot of times. They think if they can get the thing out of their name, then they don't own it anymore. But the bankruptcy code is set up such that if that's done in a certain amount of money in a certain time period, then the trustee could undo that transaction.
Claw it back, I think they call it sometimes.
Yeah.
Something like that. Yeah.
Right. I don't know if we have anything else.
Well, we can talk generally about what's going on. There's a federal lawsuit now to try to stop the eviction moratorium that I think has reached the Supreme Court.
Well, if it does, I mean, the last time they had it in front of the Supreme Court, a majority of the justices felt that it was inappropriate, whether they felt it was unconstitutional, which I think it is, and I think it's basically the pure essence of unconstitutional. It so directly violates exactly what our Constitution was set up to do. it's shocking. You know, I mean, that's one of the big things that people were afraid of back then was property being taken and getting nothing in return. Like the British would live in a house, they kicked people out, they live in the house or whatever. But that was a big, big deal. And now people think just willy-nilly, you know, governor, president, the CDC can take take the landlord's money away and not give them anything in return. And it's so I think it's blatantly unconstitutional. I don't care who did it. It's just not right. And whether the Supreme Court would hang its hat on the unconstitutionality or the fact that the CDC doesn't have the power to do something like that, and they're
An unelected group.
yeah, well, they're there to do certain things. I mean, they've got a charter that, and their tasks are enumerated, and their abilities are too. And this is something that goes beyond the scope of what the CDC would be allowed to do. But the reason that the last time it went to the Supreme Court, that they let it go, because you had 5 justices against it. Brett Kavanaugh said he didn't think it was proper, but it was only a month.
And
So, well, it was a month, and now the administration wants to turn it into longer than that. And it's just, I don't know how.
I knew I'd get Jeff going with this topic.
Yeah, I just don't know how people do that. And when they just don't have the power to. Our Fifth Amendment was created for that kind of thing, and it says that the federal government can't take your property without compensating you for it. The 14th Amendment makes that portion of the Fifth Amendment applicable to states. It says that states can't take your property and without compensating you. So, you know, whether it's a state governor or President Biden, it's not right.
Well, I think that's a good time to remind people they can call us anytime for a copy of your free book at that number.
If we don't get arrested, maybe we'll.
Yeah, as long as you don't get for Jeff was not down in Washington on January 6th. I want that very clear.
No, absolutely not.
But call, how do I do that? Isn't that good? Call that number right there. Tell the person who answers that you saw us on Facebook and you want Jeff's free book. And we're going to send it to you. And it's very, very good, very informative, and you'll really enjoy reading it.
It does help. It gives you a good overview of bankruptcy and what it's all about in kind of layman's terms. It's easy to read. If I do say so myself. Yeah. So I think that's about it for this afternoon. If you're watching us, thanks for tuning in, and we'll see you next. Actually, maybe it might be. We've got a lot of things coming up. There's holidays coming up, and this, that, and the other thing. But one of these Thursdays at 2:00 soon, we'll be back with something else that we hope you'll find interesting. So until then, stay safe.